Hey, what is going on, crypto people? It is the Crypto Siege with another day in the life and the crazy life that is the digital asset space. Wow. Did I just what? Did that just really happen? Did the Honorable Judge Torres rule and agree with every single important point with the Honorable Judge Netburn? Ladies and gentlemen, yes, she did. And let me say this as clear as I can possibly say it. It's over. It's over. It is over. It's over. Listen, the market is doing what the market does. We're going to go over that. Interesting news out of the Voyager settlement. It's just Ron Bitters saying that Voyager kind of accepted the lesser deal, or the committee and or regulators wanted nothing to do with the quote unquote utility token, the VGX token, in terms of a recovery. Simon Dixon is becoming prophetic. It's becoming prophetic. So this whole thing around the cell token, that the community, a lot of, that people, I won't even say a lot of people, but people in the community are talking about and wanting, but that cell token, it's not viable. It ain't possible. It's the regulators want nothing to do with it. And what if there was anything that we learned from that town hall meeting, that the Celsius UCC, the people working on behalf with the law firm White Case, on behalf of us depositors, if anything we learned from them, from the White Case people in the UCC, nothing's moving forward without the approval of the regulators. No bid, no plan. They're not having it. You're going to have to dot all the I's and cross all the T's with them. Period. And that's exactly what Simon Dixon is saying. That's why he pushed for removing Alex Mashinsky, removing the current board, because the regulators, it ain't a personal thing. It's the regulators. They ain't going to allow any kind of reorganization with that current board in place. It ain't happening. And now we're finding out, more likely than not, it ain't going to happen with that cell. More likely than not, it's not. The cell token thing ain't going to work. It ain't going to work, guys. It's not going to work. In my humble opinion, the vast majority of deposits don't even have any cell. Certainly less than $500 worth of cell. In my humble opinion, the vast majority. So that cell thing, forget it. I know I got guys, I got my dudes out there loyal to Celsius and the cell token. Forget it. Forget it. It's just not going to happen. And unfortunately, this is going to be another painful point for people, employees at Celsius. It's going to be a tough lesson, but you'll recover. You'll rebound from it. Trust me. I've been around the CEO God complex and all that comes with it. It can be painful, and there are painful lessons. And I'm talking billionaire CEO businesses, just like Alex Mashinsky's. Same thing. I've done it twice. I know what can happen in that arena. It's a painful lesson, but we'll pull through together. And it's looking more and more clear. I encourage you. I'm going to share you the link. I'm going to share the link with you guys of that town hall meeting. I encourage you to listen to it again and listen to it again, because they clearly said some very, very telling stuff. Number one, mismanagement, misleading, deception, illegal, fraud. Regulators are all over it. You forget about it. All over it. Alex Mashinsky is on the family first plan. Period. It ain't personal. It ain't personal. The dude doesn't wake up in the morning trying to crush you, the creditor, the creditors, like deposit. That's not it. He's waking up in the morning. How can I protect my family? And he can't do both. He can't do both. Hold on 1 second. What's up, baby girl? Huh? Okay, you okay? You got the window up? Yeah. Okay. They probably reset it, Jada. Are you talking about the gas mileage? So you put gas in and it's still not showing anything? Huh? It's gone up since I've been driving. Well, I don't even know what 5.9 means, but I'll check it out. I'll call you back. Okay. Hello? Okay. Okay, I'll call you back. So I think I'm back. That said resume share. Oh, I should. Oh my gosh, I stopped. What the heck? I thought I paused the video. I didn't pause the video. I paused the sharing. This is just we're live, ladies and gentlemen. We're live, ladies and gentlemen. But anyway, so we can, I'm going to share that link with you guys so you guys can get that for sure. Because it was very, very telling. I'm glad they did this town hall. Hopefully they'll continue to do them, at least twice a month or something like that. But in any case, the big news is Judge Torres agreed with Judge Netburn, and the SEC has been ordered to turn over the Henry emails, man. I don't even know what to do with that. So listen, guys, this is your XRP Ripple daily news, and around 0 to 10 minutes. So let's do it. Total cryptocurrency market cap is at 986 billion. Shout out to CoinGecko.com. The Bitcoin dominance is at 38%. Bitcoin is trading at $19,562. Ethereum is at $1,334. And XRP is trading at 48 cents. It's up 21% on the 7-day. And I have a feeling it's only going to get better. Solana up 7-day on 7-day, up 10% on the 7-day. I may have, no, we're not at the trade point yet. We'll see. I still got an open position on Solana. But look, guys, listen, the market is doing what it does, right? It's just doing what it does. Remember, it's less than $1 trillion. And at one time, the total cryptocurrency market cap was over $3 trillion, right? So we can't forget about that. Let's go over this here from Voyager. Again, just as real quick for my Celsians out there, Voyager's auction did not serve depositors' best interest, alleges Wave financial representative. According to the Los Angeles management firm, better bids were on the table for depositors and the community. The assets of the crypto-focused firm Voyager Digital would face a drastically different fate if FTX did not win the bid, claimed the spokesperson of Wave Financial, speaking to Cointelegraph. The spokesperson argued that better bids were on the table, but they were passed over for strictly cash offers. Wave is an SEC-registered digital asset management company with over $1 billion in assets under management. They participated in the process, bidding a slightly lower amount than FTX for the assets. FTS secured the winning bid with an amount of $1.4 billion. That's the value, not what they wrote the check for, which must now be approved by the United States Bankruptcy Court. Wave defended this proposal as the only one seeking, this is important, guys, to maintain the Voyager brand and create a new exchange model that caters to the community, regardless of the financial differences in the bid. In particular, Wave's proposal sought to restore value in the VGX token via new improved utility, saving $200 million worth of funds and redistributing assets back to existing Voyager customers, and extend a revenue share program to depositors through the new exchange model, driven by the liquidity and community of leading layer 1 protocols who joined as investors and minority owners. Layer 1 protocols joined in with Wave, this asset management company firm. Layer 1s provide utility, VGX add utility, and the regulators ultimately, because again, you got to get all these approvals, and Simon Dixon suggests Wade was the only remaining bidder during the blind auction process that took a white knight approach of prioritizing depositors' financial interests by restoring value in the VGX token and creating a long-term revenue sharing model, both of which return substantial equity directly to depositors. And they took the strictly cash only. The creditors and the regulators that didn't want to have anything to do with the utility token, guys. I know we're hearing all this stuff. They didn't want to have anything to do with this talk of utility token. Kind of just the way it is. Kind of just the way it is. Simon Dixon did a little thread here. I'm not going to read the whole thread. But I will say this. He has been right about a lot of things. Not all things, but a lot of the things in this. The headline, Voyager's auctions did not serve depositors' best interests, alleges Wave Financial Rep. Let me share my opinion on why this happened, based upon public information and what we can learn for Celsius. The hole was smaller for Voyager over Celsius, so cash bids go further than offer involving filling a hole with financial innovation. Celsius network, for Celsius, the chance of a cash bid filling a $2 to $3 billion hole is out of the equation. It makes no business sense. Wave's proposal sought to restore value in the VGX token via new and approved utility, saving $200 million worth of funds and redistributing assets back to existing Voyager customers. Do you get that? This token and this value wanting to come back to the depositors because of this token wouldn't cut it. I believe that a utility token-based proposal that involves, this is Simon Dixon, I believe that a utility token-based proposal that involves making creditors whole through increasing a token's utility is forcing a regulatory position that hinders the process of getting out of Chapter 11. It's the exact opposite of what regulators want, and it gets political. Regulators may accept security token, however, as the brokers and exchanges have been approved. Due to regulatory issue, it seems FTX simply treated the VGX as part of the estate. Sam Bankman-Fried simply treated the VGX token as part of the estate, but did not make it a focal point of the recovery plan. And this is why it was chosen, in my honest opinion. I made enemies when I stated that the CEL token should be treated as part of the estate for those that hold it on the app, and creditors must be treated fairly. But a recovery focused on a token will not be approved due to regulatory politics. This still remains my opinion on the path to recovery. You may not like what I have to say, but my role is nothing more than to optimize the outcome for creditors. It is political. Regulations do matter, and the stakes are high for hundreds of thousands of victims. For over a decade, I've been walking the tightrope between financial innovation and regulations and presenting plans to regulators and politicians. Tell me who else is getting a meeting with a president of a country, getting a meeting with him and his representatives. Tell me who else is doing that. I know there are some, but tell me. I believe the Bitcoin Cash dude's got that kind of pull as well. I forget his name right now. Roger Ver. Tell me who else is doing it. And in our case, in the Celsius community, who else is doing it? You have to take that into consideration if you want the opportunity to be made more than whole. You have to get the balance right to get the result you want. All should listen. Everyone, he's from England. Everyone should listen to the Celsius UCC town hall. I agree 10,000%. Check it out. It is recorded. You definitely want to go to @Simon_Dixon twit, @Simon_Dixon TWITT. The S is capital, the D for Dixon is capital, the T for twit, TWITT is capital, @Simon_Dixon twit. Get this recording, listen to it. I'm telling you, I spoke on the end of that recording. You definitely want to check it out. It was everything that I needed at this moment to make me understand, fully and truly understand what is necessary to move forward. Remember the UCC, you get Alex Mashinsky and Nuke were on that Twitter Spaces. They can't play their hand. They effectively forced Alex Mashinsky out of Celsius as the CEO. We also learned in that town hall that just because he's remaining as a director of the UK, he's not going to have the influence on the decision-making moving forward, even though he has that director. And that came from a lawyer who wasn't given legal advice, but it came from a lawyer in that space, in restructuring financing space. So just understand that. Let's get to the news of the freaking day. Shout out to Jimmy James Filan. I'm telling you, we're so blessed. I hope you guys take a second of time out of your day to say a special thank you to Jimmy James K. Filan, to John Deaton, to Jeremy Hogan, to Fred Rispoli, to Bill the attorney, to Attorney Seal, all these attorneys who take their time, energy, and resources to educate us. They don't have to do it. They take their time, energy, and resources to educate us and to add value to our lives in this case. We really do appreciate you guys. I hope you guys take a second to say thank you to each and every one of these. So John Deaton put this out here. Crypto law just added to our document library. Judge Torres overrules all SEC objections. Finds Judge Netburn did not err in any of her decisions. How many times have I said how blessed we were to have the Honorable Judge Torres and the Honorable Judge Netburn on this case? I got my personal reasons for that. These are just my personal reasons, but we got really, really blessed. And the digital asset space, I believe, is going to be blessed by having Judge Netburn, Judge Torres on this case. I really do believe it, because they're not putting up with the BS. They can read and see the BS, and they're calling attention to it, and I love it. Ain't no bought and paid for here. John Deaton responds and says, and wait a minute, did not err in any of her decisions, and orders the SEC to comply and hand over Hinman's emails. We said it on this channel. Bill Hinman has to be the fall. There is no other choice. He's going to be the fall guy. He's going to be the fall guy. And he's going to hope and pray that the whole $15 million thing is going to go away. He's got to hope and pray. He's got to hope and pray that Empower Oversight. Shout out to my guy DJ Jarvis for sharing that. I appreciate that, bro. And he's got to hope and pray that Empower Oversight goes away. Yo, he's got to hope and pray, baby. I hope he saved that 15 million. But anyway, John Deaton said, this is why the crypto market should be thankful. Ripple is fighting this case. If you add up the legal fees Ripple has paid to finally get a ruling from Judge Torres, it is likely 2 to 3 million, and they still don't have the documents. Next step, SEC asks to certify or a mandamus. Here it is from Jimmy James Filan. Let me share this with Jeremy Hogan said. Judge Torres agreed with Judge Netburn on every single issue related to the Hinman emails. Relevance, check. Attorney-client privilege, check. DPP, check. He says, some days I'm proud of this profession. Indeed. Now I got this thing here now. We're gonna try to read this together, okay? Jimmy James, thank you, bro, for sharing this. Here it is here. Plaintiffs, Securities and Exchange Commission brings this action against defendants RippleLab and two of its senior leaders, Brett Garlinghouse and Chris Larson, alleging that defendants engaged in the unlawful offer and sale of securities in violation of Section 5 of the Securities Act of 1933. The SEC also alleges that the individual defendants aided and abetted Ripple's Section 5 violation. On August the 10th of 2021, defendants requested a local rule conference to address the SEC's assertion of privilege, primarily the deliberative process privilege, DPP, with respect to certain documents defendants requested during discovery. After receiving briefing on this issue and conducting an in-camera review of exemplar documents on January 13 of 2022, the Honorable Sarah Netburn issued an order that, as is relevant here, found that emails and drafts concerning a June 14, 2018 speech given by William Hinman, the then director of the SEC's Division of Corporation Finance, in parentheses, the internal speech documents, are not protected by the DPP order. She's got some references here, and that's awesome. Then she says, on February 17th, 2022, the SEC moved for reconsideration or clarification on order 1 with respect to Judge Netberg's holdings regarding the internal speech documents. After reviewing additional documents submitted to the court for in-camera review on April 11th of 2022, Judge Netburn denied the SEC's motion for reconsideration and granted its motion for clarification. See Order 2. Then, on April 29th of 2022, the SEC renewed its assertion that the attorney-client privilege protects the internal speech documents. On July 12th, 2022, Judge Netburn, after reviewing additional documents in camera, found that the attorney-client privilege does not protect the internal speech documents and ordered their production, in parentheses, order number 3. I don't think it's a coincidence, and I don't think this is part of the legalese and typing this stuff out, that these orders are in parentheses. I think it's very, very clear that both the Honorable Judge Netburn and Honorable Judge Torres understand the shenanigans and quite frankly are upset with it. And we said on this channel before, they can just give them rope and give them rope and give them rope and let them hang themselves. But because it is clear that this is not about the law. On July 26 of 2022, the SEC filed objections to Order 1 and Order 2, together the DPP orders, and Order 3 collectively. For the reasons stated below, the SEC's objections are overruled. Is that normal to put it in all capitals? I'm going to have to ask the attorneys and Jeremy Hogan and John Deaton, Attorney Bill, and Fred Rispoli. Maybe. I feel like they're making some points in these typings. I really do. Legal standard: a district court may reconsider a magistrate judge ruling on pretrial matters where it has been shown that the magistrate judge's order is clearly erroneous or contrary to law. A decision is clearly erroneous when the court is, upon review of the entire record, left with the definitive and firm conviction that a mistake has been committed. A showing that reasonable minds may differ on the wisdom of granting the defendant's motion is not sufficient. Let me say it again. A showing that reasonable minds may differ on the wisdom of granting the defendant's motion is not sufficient to overturn a magistrate's judge's decision. And it is well settled that a magistrate's judge resolution of a non-dispositive matter should be afforded substantial deference and may be overturned only if found to have been an abuse of discretion. Thus, the party seeking to overturn a magistrate's judge decision carries a heavy burden. The FCC objects to the orders, arguing that Judge Netburn erred in determining that the internal speech document are relevant to any claim or defense in the case, finding that the DPP does not protect the internal speech documents, and concluding that the attorney-client privileges does not protect the internal speech documents. The court shall address those objections in turn. Relevance. The SEC contends that the internal speech documents are not relevant to Section 5 because of the evaluation of the fair notice defense is subjective, and the SEC need only show that the individual defendants disregarded the facts that made Ripple's scheme, quote unquote, illegal to establishing aiding and abetting liability under Section. The court agrees with the SEC that non-public documents like the internal documents are not directly relevant to any claims or defenses in this case. Internal documents do not bear on the notice parties received or whether the individuals knew certain facts about Ripple's offers and sales of XRP. But Judge Netburn did not find that these documents are directly relevant to these issues. Instead, in order to, Judge Netburn declined to take a narrow view of relevance in the context of discovery and found that these documents are relevant under the extremely broad concept of relevance used to resolve discovery motion. The court holds that Judge Netburn's conclusions regarding the relevance of the internal speech documents are not clearly erroneous or contrary to the law. As she noted, in order to, relevance for purposes of discovery is an extremely broad concept. Relevance is to be construed broadly to encompass any matter that bears on or that reasonably could lead to other matter that could bear on any party's claim or defense. A showing of any possibility of relevance is sufficient to shift the burden to the opposing party to show that discovery is improper. Here, defendants argue that the internal speech documents are relevant because they may be used. Okay, great. Therefore, the SEC's objection to Judge Netburn's finding with respect to the relevance of the internal speech documents are overruled. And then it goes on with the DPP, and she goes on to explain about the deliberative process as well. She gives a reason. The court also finds that Judge Netburn did not err in determining that the internal speech documents were peripheral to any agency's deliberations concerning the SEC's policy with respect to the regulation of digital asset offerings. First, the SEC contends that Judge Netburn's conclusions are contrary to law because they rely on the facts the SEC itself has not reached a conclusion about how to regulate Ether to hold that not protected. Although Order 1 mentions that the SEC has not articulated a position with respect to its regulation of digital asset offerings, Judge Netburn did not rely on that fact when concluding that the internal speech documents are not pre-decision or deliberative. Rather, after reviewing the internal speech documents, Judge Netburn found that to the extent they concern the SEC's deliberation about agency policy, as opposed to deliberation about him as personal views, they merely mention such deliberations or are otherwise relevant to them, but not an essential link. Order 2 at a quoting. Second, the SEC argues that Judge Netburn erred by incorporating a requirement that the product of the deliberations relate to the statement of an agency policy. The court disagrees that the decisions cited by the SEC stand for this proposition. And even if these cases do support the SEC's interpretation of the DPP, they do not warrant a finding that the DPP orders are contrary to law because a magistrate's judge's decision is contrary to law only where it runs counter to controlling authority. She laid it down. Finally, the court finds that Judge Knepper did not err in determining that the attorney speech documents were related to the communication of Hinman's own opinions for the purpose of deciding whether the DPP applies, or in otherwise making factual determinations about the internal speech document contents. Her conclusions were based on prior representations the SEC made. There it is. Her conclusion, Judge Knepper's conclusions, were based on prior representations that the SEC made in this litigation and applicable regulation. After reviewing the relevant materials and the arguments advanced by the SEC and considering Judge Knepper's familiarity with the materials and the record in this case, the court finds that the SEC has not carried its heavy burden of showing that Judge Knepper's determination was clearly erroneous. Therefore, the SEC's objection to Judge Knepper's finding with respect to the SEC's assertions of DPP are overruled. I'm telling you guys, it's over. I mean, this is a haymaker. Therefore, the SEC's objection to Judge Knepper's finding with respect to the SEC's assertion of attorney-client privileges are overruled. And I'm telling you, the fact that we keep seeing all these all capital letters for overruled is a statement. The court has reviewed the remainder of the thorough and well-reasoned orders for clear errors and finds none. Accordingly, the court overrules the SEC's objections and directs the SEC to comply with the orders. Conclusion: for the foregoing reason, the court overrules the SEC's objections and directs the SEC to comply with the orders. It is over. It's over. The settlement table is full. There is no way they're turning over. You know, I get it. John Deaton is saying they can do this, or they can do a mandamus or whatever else they may try to do. But ultimately, the courts are going to find that the SEC has to turn over the email. It's over. And the SEC is not going to turn over those emails. Let's see if anything, if Brad Garlinghouse or I don't know, maybe they're too busy talking. But have they been on saying anything here, Garlinghouse? Has Stu Alderati said anything about this ruling? Anybody know? We're gonna check. Let's check that and see real quick. Let's see if there's anything. Nope. Let's go check out Stu Alderati. Let's see if he put anything out, if he said anything on Twitter. Nope, nothing yet. Nothing yet. But I got to tell you guys, that's exciting. That is some big time news. It's over. I just, look, the ruling, and someone said too, I think it was my guy, Jungle Link, was saying that it'd be very, very interesting to see the Judge Torres rule before the end of September. And here she's ruled before the end of September. Is hashtag Gary Gensler. Is he trying to push up his numbers and share with the world his numbers? Is he at the settlement table? Does he already have the numbers in mind to kind of get some stuff done, by the end of this month, the end of first week in October at the latest? Is that what they're doing? We'll see if my guy, Jungle Link, is right on this one, because he just might very well be. The ruling is in. No, the ruling is in on those three things. That is massive. The DPP, attorney-client privilege. I mean, it's massive, guys. It's massive, and it's a win like none other for Ripple. I mean, relevance check, attorney-client privilege check, DPP check. Judge Torres agreed with Judge Netburn on every single issue related to the Hinman emails. All right, guys, listen, this wraps up your XRP Ripple Daily News in around 0 to 10 minutes. I hope it has been of value to you. If it has, do me a favor, hit that like button, hit the subscribe button, and please don't forget to ring that notification bell so that you know whenever I go live or whenever I upload a video. It's been a really, truly awesome hang with you guys today. I'm going to end this video like I do all of my videos and remind you guys of this.
Old money doesn't want you to win. They don't want us to win. They would rather that we remain a cog in their perpetual wheel of trading our time for dollars. They don't want us to play in the same playground that they play in, where we allow our money to work for us. This is our chance to win, guys. The digital asset space is our chance to win. We are in the midst of the greatest transfer of wealth in the history of man. Are you participating, or are you standing on the sidelines? Here's what I do know, that the battle for you has already been fought, and the victory is yours. Go get it.